So I'm Diane Harr. I'm going to do the first hour. I wanted to say I realize this is 5 hours long. The first 3 hours, for those of you who've sent off to be accredited through the VA, this is the accreditation CLE, the one that you have to do to get the accreditation. But the problem is we're going to throw a lot of information at you in 3 hours. By regulation, there are certain things we're required to talk about. It doesn't necessarily make you practice ready or even understand what the heck you're supposed to do when you sit down with a client. So that's the last 2 hours. So I will say it's not that John and I really want to hear ourselves talk for 5 hours. We're just trying to do our best to get you guys comfortable with these cases and get you practice ready, because frankly, we have a lot of vets here in Hawaii and we can use all the help we can get. And the other thing I want to say before I start, for those of you who are Democrats, the Democratic Party is starting a Veterans Caucus. This is a group of individuals who want to work on veterans issues. They're trying to get membership now, and I have the form with me. If anyone wants to fill it out and give it back to me, I will pass it over to Carlos Santana, and it's not the rock guy, it's the guy who works with Maisie Hirono, but he's the one that's handling the membership. He'll probably end up giving you a phone call. But if you're interested, I'll pass these around as well. Just give me the form once you're done filling it out. And frankly, we'd really love to have anyone who's interested. So I'll pass these on down. Okay, so with no further ado, hour one. So hour one, we're going to talk about basic eligibility for benefits. And the first thing we're going to talk about is who is a veteran. And one of the reasons we talk about this is the definition changes. Like for the Veterans Treatment Court here in Honolulu, the definition is totally different. This is the VA definition for disability. And I'm going to break it down and go through it so that you know when someone walks in your office, if you can help them or you can't. Because of course, someone who isn't a veteran by their definition can't get VA benefits. Okay, so the first part of that definition, we need a person who's served. And what that means, it's pretty easy to figure out the folks who are regular active duty. So the folks on our bases here on Oahu right now, our Army, our Marines, our Navy, our Air Force, our Coast Guard, all those people who signed up, who are serving 24/7, those are going to be veterans. We also have our reserves. They're going to be veterans, our National Guard, when they're activated to federal service. So one of the things you want to remember with National Guard, a lot of these folks have been activated to federal service because of the wars in Afghanistan and Iraq. But you will occasionally run into those that have never been activated to federal service. So you need to watch out and make sure that they've been activated to federal service. If they're not, they're actually state employees and they won't be eligible. Okay, in addition, we've got a couple funky categories that we don't see all that often. We have full-time commissioned officers in the Public Health Services, the Environmental Science Services Administration, and NOAA. And then we've got these cadets at the Air Force, military, Coast Guard academies, midshipmen at the Naval Academy, students at the prep schools for academies with active duty commitments. If you'll remember a couple years ago, there was a big issue. It was in Congress. So someone went before Tammy Duckworth claiming to be a disabled vet, and he actually does meet the criteria. He was injured playing football. I think it was in one of the academies. So this person actually does qualify for under the veteran status for VA disability. I just don't know that I'd go to someone who lost their legs in Iraq and claim to be as disabled. Okay, so we also need someone who was discharged or released under conditions other than dishonorable. So at first this sounds really easy. You look at the person's discharge document, and for those of you who don't know, every government form, you may know this, every government form is identified somehow. This, in the lower corner, will say DD-214, DD-214. You're going to look at the DD-214, and you're not just looking to make sure it doesn't say dishonorable. There's a couple different ineligible discharges. We've got officers if they have a dismissal, we have other than honorable, we have bad conduct discharges, and of course we have dishonorable discharges. These folks are not going to be eligible for benefits, or at least not eligible for benefits right off the bat. The eligible discharges you're going to look for: honorable, general under honorable, general discharges, and even these, they'll be eligible, like with a general discharge, they'll be eligible for some things, not for others. Honorable is pretty easy. If you see honorable, you're good to go. I will say for those who have ineligible discharges, they can seek to upgrade their discharges. This is generally a couple-year process, but they should do it if they have a reason to do it. If they had a full court-martial, your chances of actually upgrading that are pretty bad, just to let you know. Not impossible, but pretty bad. And one of the things that John will talk about a little bit later is he's the only one I know that's been able to do this. He's the only one that I know that's actually really tried a lot on this too. You can actually take a bad discharge, someone with a bad discharge, and adjudicate an eligible period for benefits. So someone comes out with, you know, say an other than honorable. He's been able to argue like it's PTSD and they had this honorable service, you know, say while he was in combat. And he's able to get people benefits even though they have bad discharges. And he'll talk about how to do that a little bit later, because this actually does come up a lot. We see a lot of bad paper. And the final thing to say is there may also be multiple discharges, especially with National Guard. You've also got people that go into active duty more than once. They'll have more than one discharge. So they may have one bad discharge and say 3 good discharges. If they were actually injured during a period of good service, it doesn't matter that they have the bad discharge. You can adjudicate them under that good period of service. So those are our requirements. I just said a lot of words for a small definition. So keep your copy of the slides and just use that when folks come in your office to figure out if they qualify as a veteran. But I will say, you know, you have someone come in, he's got an honorable discharge. If he was regular active duty, that one's going to be pretty easy. That guy's going to be eligible. Okay, so the types of disability claims we're going to talk about today. I want to let you know there are more. So considering this is the accreditation CLE, we're only talking about certain kinds because we can't pack any more into this 3 hours. We're going to talk about the Veterans Service-Connected Disability Compensation, the Veterans Non-Service-Connected Disability Pension, which will start the 2nd hour, and Dependency and Indemnity Compensation, which will be the middle of the 2nd hour. So I'm going to go into Veterans Service-Connected Disability Compensation now. Okay, so this is the one that you most commonly see. It's the one that most veterans want. This is the compensation they get for something that happened to them in service. And I'll break this down. So you have minimum duty requirements. For the regular active duty guys, they only have to have served 1 day. So they can get injured in boot camp and get benefits, theoretically. So there's different requirements for different folks. Of course, the National Guard has to be activated to federal service. We have some exceptions here. There's an exception for cardiac arrest and stroke if they're going to during or returning from active or inactive duty for training. I don't know why those exceptions are there. I won't go into this so much, but this should be in your handout of the slide, so you can look this up as well. And then we have the other folks I was talking about, the folks in school and the commissioned officers. Okay, so these are the types of service-connected disability compensation claims, and there are 4. Direct service connection is the one that you're probably going to be talking about the most often. I could be wrong, but this tends to be the most common one. This is something, it started when the veteran was serving. This is the guy, he goes to Iraq, he blows out his knee. That's what he's going to get service connected for. He's going to get service connected for blowing out his knee in Iraq. There's also secondary service connection. This is something where the veteran is already service connected for a medical condition. So this is the guy, he goes to Iraq, he gets blown up, he has a traumatic brain injury. He's service connected for that, and he comes back 5 years out, 5 years after he's left service. He's really depressed, and he's really depressed from the traumatic brain injury. He can get secondary service connection for that. That can be piggybacked right on to the traumatic brain injury. So there'll be 2 separate claims. I think actually the best example I ever heard, and I love this one. So most vets come back hard of hearing. I know of an attorney who had a guy, he was service connected because he was hard of hearing. He's out in his boat. He's motoring around in his boat, and he moves his boat. He doesn't hear the boat coming up behind him because of his bad hearing. The boat coming up behind him runs into him. He goes over the side. He busts up his knees, and I don't know what all. So the attorney that I know actually got him secondarily service connected for busting up his knees. But for the fact he couldn't hear the boat behind him, he wouldn't have moved the boat. So that's the secondary service connection there. So that's secondary service connection. We've also got aggravation. This is for the guy, he's playing football in high school. He injures his knees. He goes into service, and then it goes beyond the mere progression of the knee injury. His knees get 1,000 times worse. Say he's blown up in Iraq and his knees get 1,000 times worse. They're going to service connect him for the aggravation. So it's not going to be entirely for the knee injury, and we'll go over exactly how this works. But they're going to service connect him for the aggravation of the knee injury beyond what would have been expected had he not served. And then the final ones are the presumptives. These are the ones when they walk into your office, it's kind of a sigh of relief, and I'll explain why in a minute. But these tend to be a lot easier, and I'll explain that in detail. I won't go into it yet. One of the things to know, with every service-connected disability compensation claim, there are 3 elements you have to meet. So this is the rule, 3 elements. First element, you have to have a current disability. It's not enough that they got blown up in service. They got blown up in service and they busted up their knees. If they're fixed now, it doesn't matter. So there's a current disability, and that can be, my examples, PTSD, diabetes, knee degeneration. You have to have a medical diagnosis. So the thing to know, I don't recommend doing this unless you have no choice. And here in Hawaii, we get a lot of calls from people in other countries. So theoretically, you might be able to find a way you'd have no choice. If you have someone come in and he doesn't have a diagnosis or any way to get one, you can make the claim to VA and try to trigger them to make the examination themselves. So they have doctors who do compensation and pension examinations who can do an examination to see if this guy has this injury. You're a lot better off to actually have the diagnosis before you start, though. So here's a practice tip. Someone comes in your office, they say, I don't have any medical insurance, I can't go to the doctor. They're a vet. Go online, get a 1010 easy. It's a short document. Have them fill it out, take it to VA. Every veteran is eligible for VA healthcare. Sometimes there's problems with VA. John and I have talked to the folks up there, and this is the healthcare side. Every veteran who served and has good paper, good discharge, is eligible for VA healthcare. So get them to fill out that 1010 and send them on up. Explain to them that their chances are going to be 1,000,000 times better if they go to the doctor and get that diagnosis, rather than trying to make this argument, A, trying to trigger VA to actually send them to that exam, and B, hoping whoever they see for that hour, less than an hour, actually finds it. So that's a long way of saying, try to send them off for the diagnosis unless you absolutely can't, in which case you can make the claim to trigger VA to do it. And the final thing that I asterisked is pain alone is not a disability. And I only say this because, first of all, you don't want to make the claim for pain. But second of all, you get a lot of guys coming into your office and saying, well, my knee really hurts. You need to break it down. Is it knee degeneration? You know, what's going on with his knee? You need a diagnosis. It can't just be pain. So that's element number 1. There's something going on now. Element number 2 is something happened in service. So this is the service-connected part. So the easy one was the direct service connection that I was talking about, and that's, you know, the guy gets blown up, injures his knees in service. The secondary service connection is it's attached to something that happened in service. The aggravation is the aggravation happened in service. And the presumptives, which we'll get into, the veteran served in the area of exposure or was exposed to whatever it was that he's going to be service connected for. And I'll get into that in detail, so don't try to figure out what I'm saying now if it doesn't make sense. But in any case, now we have two elements. There's a diagnosis now, and something happened in service. We're going to go on to element number 3. This is what most commonly is going to walk into your office. This is what most people don't have. Element number 3, there's a medical nexus between the event in service and the current disability. So it's not enough that the guy got blown up in service and his knee hurts. You know, even 2 years later, he comes and he makes a claim. He's got a knee diagnosis now, he got blown up in service. He's got to have the medical nexus. And this can be super frustrating because you can look at the records and pretty much guess this is the same thing. You still have to have the medical nexus. This is your proof. So direct service connection, you need a doctor that says it's as likely as not this disability is related to the event in service. And when I say service, I should also clarify, I'm not talking about just getting blown up in combat. I keep using it as an example, but I really shouldn't. So for guys on active duty, he could be out driving to the movie theater on his off hours and he gets in a car accident. That works too. They're viewed as on active duty 24/7. So guys that are full active duty, it's anything that happens 24/7. I mean, you know, it's even if they fall over the dog, you know, it doesn't matter. It's whatever happens. It's a little harder for National Guard and for other folks who have to be activated to federal service. It has to occur during that period of time. And in that case...
Talking about an LOD?
I am. I was wondering whether I should bring it up or not.
Well, we can talk about it. You know,
we have an example in your handout of an LOD. It's a line of duty determination. Thanks. I get so used to the acronyms, it takes me a minute. So it's a line of duty determination, and it's something that you will hope, it's too rare, but you will hope your person shows up with this. National Guard, they get injured, they're active duty, they need an LOD. They need someone to have written down, this person was injured in the line of duty. That's going to be your evidence in service. Active duty don't need that.
And the exception that we have, that we've carved out, and I've won this on appeal, is that if you do not have a line of duty determination for a reservist or a Guards member, you can use a contemporaneous medical report or police report. And I've won that on appeal, so we'll talk about that as we go. But the LOD really, VA will hammer that. If you bring in a Guards man or woman and they don't have an LOD, VA will deny. I can assure you, you will go before an appeals panel before you get the benefits. But you can prevent.
I will say the National Guard cases are a lot harder. And it is because they have to be activated to federal service and because you really do need the LOD determination. They scrutinize those a lot more than they do the regular active duty cases. So we're on element number 3. So for regular active duty, this is for aggravation, this is for direct service connection, this is for secondary service connection. You basically need a doctor to say, it's as likely as not. And as likely as not translates down into, there's a 50-50 chance this could have started in service. This could have been aggravated in service. This could be related to the thing that happened to you in service that you're diagnosed with. You know, it's just a 50-50 chance. I will say, well, first let me say, VA doctors are not allowed to do these. Sometimes they will. They're not supposed to. So VA has decided it's a conflict of interest for their own doctors to help with disability, that they're only there for medical treatment. So vets can go to their doctors and ask, don't expect the VA doctor to do it. This is where, I don't know how many of you are aware of this. So VA now, you can use it as a medical insurance program here in Hawaii. Go to doctors who accept the Veterans Choice Program. This gets them out of the VA system seeing private doctors. A lot of the times the private doctors will do these. So if you've got a vet, considering you're most likely to be stuck on the third element, if you've got a vet, you need a nexus, all he goes to is VA. Get him to flex that Veterans Choice card and go to a doctor, go to a private doctor who accepts the Veterans Choice Program, and have that doctor evaluate him. Have that doctor treat him, evaluate him, get to know him, and figure out whether that doctor might say, whether it's as likely as not, that this is connected to what happened in service.
I
Uh-huh.
The thing to remember when you're sending a veteran out into the field to see a physician, a lot of doctors will refuse to give you an opinion, just a flat opinion. But as Diane says, if you engage in treatment, that's the key. Always send your client to engage in treatment. A doctor is much more likely to help his or her client if the patient goes there and says, "Doc, I need help with my back." You know, if you go there and say, "Doc, I need an opinion so I can get VA benefits," most docs are going to shy away and say, I can't do that. But if you go there and engage legitimately with a physician for treatment, then that physician's records will then reflect the nature of the nexus. You can also use that same technique with VA if you need to, because veterans legitimately engage with VA physicians every day. Now, they may not be able to write a nexus letter, but I can assure you in the SOAP notes, if anybody's familiar with medical records, you know, in the objective and assessment data in medical records, you're going to find your nexus. But what you've got to do is have your client engage with that physician and actually get treatment. If you do that, then you comb the records, you can find the nexus. And certainly a court can do the same thing. And that's what courts do. When you go before an appeals judge, they're going to want to know, they're going to want all the med records, and they're going to have their lawyers on their staff comb those records, and then they're going to bring them to the judge and show precisely what they've got. That's how you find a nexus oftentimes. Sometimes also you can get a specific nexus letter. So, you know, it's a mixed bag, but go there for purpose of treatment, that's how you win.
But I'll say one of the reasons I'm recommending the nexus letter is VA will send this person to their own doctor to see if there's a nexus.
Yeah.
It's a roll of the dice. They don't send them to this doctor for treatment. This doctor sees them for an hour or less and forms an opinion. Now, the thing with VA is everything's 50-50. It's the benefit of the doubt, and we'll go over this too, the benefit of the doubt doctrine. When it's 50-50, the benefit of the doubt always goes to the veteran. When you have a nexus from VA that says no, and a nexus from his doc that says yes, you win. Now, VA has ways of writing this to get around it. I see you smiling, I know you know this. If they really don't want to grant this guy, you'll get an opinion and it'll say, well, he didn't review the service treatment records or X, Y, and Z. So a lot of the times I will send the service treatment records to the doctor. I know a number of the doctors that take the Veterans Choice Program. If you do this practice, you get to know him too, so you can talk to him about, I need the nexus letter, I'm going to send all this stuff over. And he'll write it the way that it needs to be written to kind of avoid this. It doesn't mean you'll 100% avoid it, but you're a little ahead of the game because you've at least hit the benefit of the doubt. And you'll notice, one of the things you'll notice is I'm talking about direct service connection, I'm talking about secondary service connection, and I'm talking about aggravation, and I'm talking about all of them needing this medical opinion. This is why you're going to love it when the presumptives walk into your office. You don't need the letter. So, oh.
You just said not to, that the VA will not give an opinion as to element 3, the nexus element?
Oh, that's the VA healthcare. So let me clarify. There's two different components of VA. There's VHA, which is Veterans Healthcare Administration. That's the VA clinic up here. That's where people are going to their doctors, they're going to treatment. Then there's VBA, that's the Veterans Benefits Administration. Same building up in Tripler, catty corner, about 1,000,000 miles away. That's the benefit side. So the healthcare side, when they're going to treatment with their doctor, those doctors have been told it's a conflict of interest for them to give an opinion. They won't give an opinion. When the benefit side sends it to one of their, what they call compensation and pension examiners, and these are doctors that work for BVA, I think they're still over on the clinic side, but they work for BVA. Those guys are employed only to give opinions, and that's what they do.
And the saving grace is now they're using a lot of private contractors, which we really prefer.
Some
I
days.
don't want to down talk the VA completely here. You know, there are some fine doctors there, but I really like the private contractors. They're much more objective. So that's really a decent thing.
So what was the name? It's a VBA doc. What's the other one? The
VHA, Veterans Healthcare Administration. And that screws a lot of people up. So VA is two different entities. Healthcare is one thing, benefits is another. They're both under the umbrella of the Department of Veterans Affairs, but healthcare is separate from benefits. They're two different entities. And actually, let me ask, how many vets do we have in the room? Well, for those of you who've dragged yourself up to Tripler, you may or may not know this. We've got the clinic on one side. It's catty corner up against the mountain. And then on the ocean side, the long way across the facility is the benefits administration. And these really are two different entities. I hope that helps.
Okay, so were you saying that this is the case only with element 3, or is it also true to elements 1 and 2 that they're not going to give the opinion?
No, with elements 1 and 2, they will. Well, they will for element 2 if they actually treated him in service, but of course that's not going to be a veterans doc. That's going to be an actual active duty doctor, usually. Maybe a private doctor.
So for element 3, could we send them to the CFP doctors, the VA doctors?
VA will anyway. But that's where I'm saying you don't always want to roll the dice. You just don't. They're going to go see the CNP doctor, and they're going to see him for less than an hour, and it really is a roll of the dice. You know your veteran, and you can know this guy should have it. The doctor sees him for less than an hour. He may not form the same opinion. If you want to know what's going to happen with your veteran, if you get this second opinion, because of the benefit of the doubt doctrine, because VA has to give the vet the benefit of the doubt, it's no longer a roll of the dice. You win.
You keep saying that the doctor will see them for an hour or less than an hour. Is that like a statutory guideline that they can only meet with them for an hour? They can't consider any of their information or meet with them again?
They consider their medical records, but they're time limited. So there's
But by what? By a regulation or statute? Or
no, not by regulation or statute, just by how the appointments are
That's your
set up.
experience.
Yeah.
They take about an hour and that's it.
Yeah. I mean, it's less sometimes. It can be more. So one of the things with veterans claims, you may have a veteran with 20 different physical claims. And if they send that all to the same CNP doctor on the same day, that's going to be more than an hour. If you have a guy with an injured toe and they send him to a CNP doctor, that's probably going to be less than an hour. So it also depends on how many claims, but it's not going to be, one of the ways of saying it too is it's not going to be regular treatment. They're not going to be seeing this person over and over and over. They're going to have that one shot, and that's all that doctor gets.
And with psychology, that's especially problematic because, a psychotherapist engages with a person with mental illness. A CNP doc sees them for less than an hour, perhaps an hour, and if they're a skilled interviewer, perhaps they can learn something. But months or years of psychotherapy indicate the real truth behind a psychological problem. So that's what we argue. We argue psychotherapy to a judge. And of course, we emphasize that the veteran has to go to psychotherapy as well. So that's how you can tell a real case from something else. Is a person really going to engage in therapy? Or are they really interested? Perhaps it's going to take some time to find the right psychologist. But that's the way you win a case, is to actually get them to engage with a therapist. Otherwise, when you go before the judge, you've got nothing except for a CNP opinion that says, no, there's no problem here.
And I'll say one of the difficulties too is a lot of vets, I mean, they learned how to tough it out while they were serving, and they get before the doctor and they don't tell them how bad it is.
Right.
So with the regular treatment, it comes out what's actually going on a lot more than the 1 hour shot where they may be having a bad day and they just don't want to talk about it. So presumptives. So this is element number 3. Presumptives mean you don't have to get the nexus. It's why you love it when these people walk into your office. They rarely do. So most attorneys handle appeals. And most of these folks usually don't end up on appeal. But what the presumptive does is it presumes if the person has a specific diagnosis, and if they were exposed to something specific during service, or they're in a specific place during service, it's presumed that nexus exists. And we're going to go through what some of the presumptives are. So chronic diseases and continuity of symptomology, these used to be two different things, and the regulations make them look like two different things. Right now we have a Court of Appeals for Federal Claims case that's made these the same thing. We're hoping it gets overturned one of these years, so if anyone's interested, we'd love it if you went for it. But basically, the best way to figure this out is go to the chronic diseases at 38 CFR 3.309A. There's a list of diseases there. I've got some examples here: diabetes mellitus, arthritis, tuberculosis. If these manifest within 1 year following the veteran's service, they can be service connected. It's presumed that this originated in service. The nexus is basically presumed to exist. So just follow that list. If you find someone who's out with less than a year and has one of these diseases, he'll fit either under continuity or chronic diseases, and he can get benefits. Okay, post-traumatic stress disorder, there's a couple different presumptives, and I will say hour 4, we're going to go a lot more in depth in mental health claims, because one of the things that comes with disability, and not everyone's disability, but with a lot of the disabilities, is mental health issues as far as struggling with the disability or just straight up PTSD. So we'll go through this a lot more in hour 4. But post-traumatic stress disorder, one type of presumptive is for personal assault. Personal assault includes military sexual trauma, which I know you guys have heard of because it's been all over the news. And this, there doesn't necessarily have to be a diagnosis in service. There just has to be evidence that something happened. The person changed while they were serving. That's looked at by a mental health professional, and if they can say it corroborates what this person is saying about being sexually assaulted, it's taken care of. So they don't need the specific things in service to show it actually happened. And this is because a lot of folks won't have gone to the doctor. They won't have reported it. They might have hid it, but it might show up. They might have had a stellar career, and all of a sudden they stopped going to work, or their career tanked, or they're putting in for a transfer, or they're struggling. That's what you want to show VA. That's going to be what you're going to use to service connect these folks. Okay, combat vets. So this is not just post-traumatic stress disorder. This is any disease or injury. So it's recognized when vets are actually in combat, and don't confuse this with a combat zone. So a lot of guys are in a combat zone, but they're not necessarily in combat. When vets are in combat, it's recognized they're not taking a break to go to the doctor. They may not get to the doctor. There might not be anyone keeping medical records. It might be their buddy who's patching them up. So with these guys, they can submit for PTSD, for other things, they can submit a lay statement or other types of evidence that they can gather together. And as long as this says consistent with circumstances, conditions, or hardships of such service, basically, as long as it passes the sniff test, as long as it doesn't sound so outrageous it couldn't have happened, this is the presumptive. They can get service connected for these conditions. There's a bunch of presumptives, by the way. Gulf War syndrome. So the interesting thing about Gulf War syndrome, these are undiagnosed or medically unexplained chronic multi-symptom illnesses. And I missed this on the slide. I was trying to update them for this year, and I missed this one. So now they've kicked out, it has to manifest to a degree of 10%. Now they've kicked out the date to December 31st, 2021. So presumably, we're going to be in the Gulf War till at least 2021. But the interesting thing is, these are undiagnosed or medically unexplained chronic multi-symptom illnesses. So you'd think when you're looking at someone's medical records, you'd see someone with a bunch of complaints and no diagnosis. That's not actually true. What VA is looking for, apparently these aren't diagnoses. Fibromyalgia, chronic fatigue syndrome, and what they call functional gastrointestinal disorders, generally irritable bowel syndrome. Those three are the big three. That's usually what they're looking for. If you just have a collection of symptoms, you can still argue it. But if you have one of these, you're good to go. Granted, they have to have served in the area, so they have to have served in that theater. They don't have to have been in combat. They don't even have to have been in a combat zone. They just have to have been in that theater to get this presumption of service connection. So infectious diseases, this is another one with a list. And these are ones that manifest to 10% within 1 year of separation from service. There are exceptions. But you're going to look up the list at 38 CFR 3.317C2. There'll be a whole list of things. If these pop up within 1 year of them leaving service, they will be presumptively service connected for these. So there's no nexus needed. The ones that can last a little longer, malaria, visceral leishmaniasis, I have no idea what that is, but it must be terrible, and tuberculosis. I'm sure by now it feels like we're going to be doing these forever. Few more presumptives. I'm going to skip down to Vietnam because those are ones that you'll actually see quite often. We don't have as many Korean War vets. You may see them from time to time. But I'd advise, look up the list. I've periodically had to appeal those. I've always been surprised when I have to. There's a list of, with Vietnam vets who were actually boots to ground in Vietnam, a list of things that they can be service connected for due to exposure to Agent Orange. And two of the most common, diabetes and prostate cancer. There's a lot more on the list, but those ones tend to be really common. My last appeal that I had to do on this was a heart condition, actually. So sometimes VA does miss it. The list has gotten pretty long. I'll say for the rest of these, they all have lists as well. There's the tropical diseases or disorders. POWs don't really need a list. You know, if you're a POW, you get the benefit of the doubt. I'd be really surprised if you have a POW come in your office. I think most of them are 100%.
Right.
Yeah. Have you ever seen one?
No.
I haven't seen one
No,
either.
the VA is
I mean, not to
very
serve.
understanding of, because these people have been subjected to such extreme circumstances, let's put it that way. So, you know, whether it be chronic dysentery, heart condition, et cetera, sight condition, they're going to get connected.
Yeah, I have to admit, I think if a POW came in my office, the first thing I'd do is make sure he was actually a POW. Because I'd be really surprised.
Right.
Then we have the radiation exposed veterans. And those you'll see from time to time. There's also a list of conditions manifesting at least 10% at any time after service.
What does that mean, manifesting to at least 10%?
Oh, sorry. So there's the schedule of ratings, which I'm trying to see which slide it's on. Hopefully it's next. No, it's not. So we'll skip up to it. This is what the ratings look like. So when I'm talking about getting people rated, this is the rating for the spine. They're sort of incomprehensible. Even if you're a doctor, I've seen doctors look at these and say, what? Like, this isn't how I would think about it. I mean, I could be wrong about that. I'm not actually a doctor. But this is what a rating looks like. And when you're looking at the ratings and you're looking at your vet, this is going to rate their condition now. So you're going to have your three elements. You're going to have something happened in service. So this is the back rating. Something happened to this guy's back in service. He's got a back condition now, and there's a nexus. You're going to look at this based on his condition now and say, so cervical spine is the neck. He's got forward flexion of 15 degrees or less. You're going to look at it and you're going to think, okay, this looks like a 30%. That's what you use the ratings for. There's a couple things to notice about the ratings, though, that are kind of funky. If you notice, this one, there's a big gap between 50 and 100. So these ratings don't actually take into account everything that could happen. We'll get into this more in a minute, but there's a lot of ways to kind of work around the ratings, too, because if all we had was the ratings, they'd have to meet this specific criteria or they'd be out.
Can I throw one little piece in?
Sure.
The lady's question about 10% manifestation within a year, if I can translate this, effectively it means the condition actually has to be disabling. And what I mean by that is, there's also a 0% rating, okay? If the veteran's rated 0% and it's legit, there's something there, but it's not disabling. So what the law is really saying is, you've got to have some kind of a bona fide disability. And then what Diane just showed you, that's one example from the ratings table showing the gradation of actual disability. So that law that you asked about really is saying you've got to be legitimately bona fide disabled for that condition within a year. Does that make sense?
Yeah, I
A
just
little
thought
bit?
it might be, are you 10% pregnant kind of?
No, it's like you've got to have some form of disability and not just a condition that's kind of dormant, if you will.
We're going to get back to the ratings in just a second, but I wanted to point out the disabilities that won't be compensated. So there's certain things that won't be compensated. Anything related to drugs or alcohol. So if a guy is drunk driving and gets in a car accident, forget it. He's not going to get VA disability for what happens there. Other ones, presumed willful misconduct, venereal disease, anything someone does while they're AWOL. A lot of these presumptions are rebuttable, but like I put there, it's really difficult. He's also not going to get VA disability for birth defects, refractive errors of the eye, so you have to wear glasses. VA is not going to give you compensation for that. Intellectual limitations, they will give you compensation for traumatic brain injury, but this means the ones from birth. And I skipped over personality disorder because I wanted to come back to that. So I know the DSM says that personality disorders don't manifest until adulthood. VA believes these things manifest in childhood. They hold that out. So if they diagnose you with any type of personality disorder, you can't receive compensation. And it's been really bad in the past. I had a couple vets that I adjudicated depression for. They tried to commit suicide in service. And this is in the 90s. See, they were both in the 90s actually. And VA diagnosed them with personality disorders. Personality disorder, you can't get VA benefits for. You're also found unfit to serve, so they just boot you out. In this case, with one of the vets, they had come into the facility, the psychiatric facility where she was, and her diagnosis was changed and she was released from service. And then they put it on their DD-214. So one of the things you may find when you're looking at someone's discharge papers is it may say reason for separation, personality disorder. One of the reasons I point this out, there is a nonprofit in DC called, I'm going to go with the acronym, NVLSP. I want to say National Veterans Legal Service Program. It's something along those lines, but NVLSP. They're adjudicating discharge upgrades. So if you have one of these people come in, I've seen it with suicides, attempted suicides. If you have one of these people come in and you can adjudicate VA disability, get them depression, that's what I did with mine. NVLSP will help them with their discharge upgrades to get that off their discharge papers. And one of the reasons that's important is for federal jobs, for schools, for all kinds of things, they actually have to produce the DD-214. And here's this pretty damning diagnosis. So anyway, that's one way to help those folks. But you cannot help them get VA benefits based solely on a personality disorder.
And I'm sorry to say, it's often the habit of the military, if they want to get rid of someone, they peg him with a personality disorder. They may well have a bona fide psych disorder, but they put them out with a personality disorder. You may be able to refute that, but it's
I'm just hoping they're not still doing it. I mean, all my clients were in a while ago, so.
I think it still happens. It's my position.
So I skipped over the rating that we went over. These are the common elements you're going to see in rating, and I went over the benefit of the doubt doctrine. So this works for everything, not just for medical nexuses. Wherever you have 50-50, wherever anything is equal, against the veteran, for the veteran, it always goes in favor of the veteran. Granted, sometimes this is the appeal. A lot of the times this is the appeal. Oh, by the way, VA, you missed this. But the veteran is always supposed to get the benefit of the doubt. This is similar. The uncertainty goes in the veteran's favor. If 2 ratings can be applied, he gets the higher one. So one of the things you want to check, one of the things I do when I'm appealing is I always have a good idea of where I think my veteran should land in the ratings. And if he lands somewhere else, you want to check and see, could they have used the higher one? Because you can actually appeal that. Because if both could be applied, he should get the higher ones. Another thing to know, the same disability cannot be rated under different diagnoses. So let's go back to the traumatic brain injury example. So if depression is made part of the traumatic brain injury rating, which it can be, then you can't be separately related for depression due to the traumatic brain injury. Hopefully that makes sense. If it doesn't, it eventually will. Analogous ratings, this is what's going to help you out with the fact that the schedule of ratings are these specific criteria. A lot of the times, you're going to look at the schedule of ratings and you're going to look at your veterans' medical records and they just don't match. I mean, doctors aren't writing for these ratings. The ratings are the ratings. Your guy may even have something that's not in the ratings. That's where the analogous ratings come in. So you can make the argument, this is close to this. You choose a rating, you say, this is close to this rating. It's really close to this rating. Here's why it's really close to this rating. This is why, VA, you need to rate it based on this rating. So it's why you'll see guys, like, they're rated for flat foot. They have a foot deformity. It's not flat foot, but they're rated for flat foot. That's an analogous rating. It's something that they've given them so that they can rate them and actually give them compensation because it's close enough to what they have. And you're going to find that you argue these a lot. Then we're down to the 0% ratings, which John was talking about. The one thing I want to say is 0% sounds like, who cares? We care, and here's why. The longer someone's out of service, the harder it is to get them rated. The evidence gets stale. Medical facilities may only keep the evidence for so long. It may get lost. 0% are like placeholders. So let's say you have this guy, he comes out of service, he injured his knees in Iraq. They're really not so bad now. He's had surgery. You can actually get him 0%ed for that, especially, you know, if you suspect it's going to get worse over time. And, you know, with injuries like that, with, say, knee degeneration where he's had to have surgery, you know, you've got a guy who's in his early 30s, he's probably going to feel it when he hits his 60s and 70s. So that 0%, he can go back to VA. You've already done a lot of the work. It already shows that this is service connected. And he can say, I need an increase in the rating. It's gotten a lot worse. And that's a lot easier of a claim than it is for him to go when he's 60 or 70 and, you know, 40 years out of service to try to get the whole thing service connected. I'm not going to go through the math too much because we're all lawyers here and I'm sure nobody's too wild about math. But I wanted to put in what the aggravation actually looks like. See, so my example was eczema. So someone comes into service, they do a medical evaluation to see how that person looks before they come into service. They find the eczema, they write down how bad it is. The guy comes out of service and he's covered in the stuff, so he goes in for a claim. They're not going to rate him just for the eczema. They're going to rate him only for the aggravation. So if it is entrance into service, they look at the records and they see, oh, this would have equated to a 10% rating. And then after he gets out, they look at him and they say, well, what he's got now equals 60%. They're going to subtract that 10% because they're going to say, you came in with 10%, so we're not giving you the 10%. We'll give you 50%. So that'll be his rating. It won't be the full 60, it'll be the 50%. But there's no deductions for aggravation if the current disability is at 100%. So if he's totally covered in the stuff and he's 100, they won't subtract the 10%. Or more commonly, this is what happens a lot. They can't figure out how bad it was at the entrance. I mean, the person might have wrote down that something was there, but that's all they have and there's no other records. If they can't figure it out, they can't subtract it, so they don't. Or at least they're not supposed to, and that's another appeal you'll find yourself making. Okay, this one, I felt the need to put this in here. One of the things you're going to find right away, you're sitting in your office, someone brings in a ratings decision, and my example here, you've got a guy, you're looking at his ratings, he's got a 50% and he's got a 40%, and VA's paying him at 70%. Sadly, that's not an error. VA has special math that they use, and I'll briefly explain the math. There's a table you can use. If you use Google, it will give you calculators you can use. So you don't actually have to learn the math. For anyone that's interested, I'll briefly explain what's going on here. So what VA is doing, they adjudicate someone, they find that he's 50% disabled for one disability and 40% disabled for the other. They're going to stack the ratings like this, highest to lowest. They're going to take the first rating, they're going to say, okay, we've got a guy who's 100% well, we're going to subtract this 50. So now we've got a guy who's 50% well, and yet he's got this 40% disability. So instead of taking 40% from 100, they take 40% from the remaining 50. What that equates to is 20%. So the closer you get to 100, the less disabled, or the more disabled you have to be. Like, the less disabling each rating is. I think it takes 23 10% to get to 100. A veteran rated 100 on the schedule who doesn't have one single 100% rating will generally, if you straight add, his ratings will generally add up to 250. Here, this guy, this is how 50 plus 40 becomes 70. So even if you didn't understand that, just understand most folks don't know this, including vets. They get the rating decision. They're so upset. They go to VA. They don't understand what the heck VA said other than VA told them, we're not changing it. So they come to you. Even if you don't understand the math, understand that it's a screwed up system, but this is in fact right. This is how it works.
If they come and talk to me, which they often do, I tell them this is the handicapping table. That's what I call it. That this is what VA will do to average out your rating. Yeah, and as she says, there's nothing we can do about it. Now later, we're going to teach you individual unemployability, and that's the balance point against the handicapping table. So there is light in all this.
Although VA uses this as an excuse, as this is supposed to make up for it. So this doesn't. This is the bilateral factor. So bilateral factors, if you're disabled on both sides, same thing, both sides, 2 arms, 2 legs. If both of your arms are disabled, you get a bilateral factor. If both of your legs are disabled, you get a bilateral factor. So the example here, we're going to take the 50 plus the 40. Left arm is rated 50%, right arm is rated 40%. Total disability is 70%. So the bilateral factor is 10% of whatever the total disability is. So here they're going to add 7%. So it doesn't come up to 90% still, it comes up to 80%. But they'll add a little extra 10% if both sides are disabled. Anyway, I don't want you guys to miss your 10-minute break because this is a really long day. I also don't want you to feel like you can't ask questions. So I think we should release you for your break, but if you have questions, feel free to hit me up.